Hello, Byron.
Confess.
Yes, it's all set now.
Hello, hello, hello.
It's I was I'm in Isiolo. I'm in Isiolo, and the network is terrible around here. So the hotel was trying to sort out the Wi-Fi issue.
Okay.
Okay.
I can see Ogada is logged on. And Claire was online, but she's disappeared.
Perhaps we can
Panelists.
a call.
City.
Hi, can you hear me?
Perfect. Okay. Okay, so did you all sort out who's going first and who's
Hi,
speaking
Byron.
and so on?
Byron, hi, how are you?
All right, good. Good to see you, Ogada, or at least hear from you. So this is how it normally goes.
Yes,
I will do a brief introduction,
yes.
and then I will turn it over to the moderator. I see Claire has joined us as well.
Great.
Good afternoon, Claire. I hope the campaigns went well.
Oh,
So I'll do a
give the
very brief
briefing.
introduction of 1 or 2 minutes. I
Uh-huh.
will then turn it over to the moderators,
Yes.
who will then introduce Sidi. Can you tell us briefly who you are, what you do, a brief bio of you?
Yes.
Sidi.
Yeah. Okay, what do you want to know? My name is Sidi Kirenge, not Kirenga.
I want to see you. I want to see you so that I don't pass you by the road when I see you.
Sorry. There's something up with my settings. Let me just change that. But in the meantime, I'm Sidi Kirenge, and Persecution Council based in Eldoret.
Great.
Yes. What more do you need to know?
And
Sidi,
just
how
that and
many
your
years of
tests.
Sorry?
How many
How many
years
years
of
of
practice?
practice?
I got admitted in 2016.
Perfect.
Hey,
Wow, that's
yeah.
good.
You are
Because I
a
know this morning
you're a
I
fossil.
got a few queries on this. They said the topic is mastering criminal litigation. So okay, 7 years is good. So Ogada, this is some of the things you'll have to say. Blah blah blah.
Yeah. Okay. I get the script. Okay.
Yeah. So
Sawa.
I'll do my little introduction, hand it over to the moderators, and then the moderators will introduce CD Karenga. She'll do her talk. And then Claire and Ogada just keep prompting people and querying people. Once she's done, then you moderate the session, go through the questions, refer to people's names as well. Keep it active.
Let me ask you, Byron.
Yeah.
Do we only have she's CD or Cindy?
CD Kirenga.
Should we, do we already have CD or there's another speaker also? You told me Jamu is sick.
Well, Jamu is sick. We've been looking for someone else, but
I think there might be somebody else who may join us later, but I need to confirm because everyone is in court right now, so we'll have to wait for them to come out of court.
Great. Then give me the 10 minutes. I finish my meeting, then I join.
Okay,
just
that's fine.
One more point. I think we might not delve so much into the issues of the appeals. Otherwise, we'll be here for a very, very long time. Is that okay with the moderators?
Yeah, but Sidi, remember you're in control as well, so you can deal with it very briefly.
All right.
As well. And then you can always say that any other queries or whatever, you can always get in touch with any of us.
All right.
So that will always alleviate the pressure on you.
Okay, that's fine. Thank you.
Okay. Oh, one thing, you'll probably have to turn your camera on if you don't mind.
Yeah, I'm doing that just now.
Yeah. Okay. Cool. Okay. I don't think there's anything else to discuss. I think we're all on board. Let's just wait. Boniface, do we wait? Do we start admitting people or?
Yeah, I think that will be okay.
Okay, let's start admitting them. And then we'll just wait. When we've got a significant number on board, we'll start.
All right.
Okay. Go ahead. Afternoon, Mary. We haven't started yet. We're just waiting for the numbers to go up, and then we'll be starting in just a few minutes. Meanwhile, good afternoon to Cynthia Osiro. Edaki, we were in Kakamega just now, so it's good to see you logging on. You must have listened to me telling you to log on to the webinar. I see Lamesh is also online. Mary from Mombasa, Mary Kiruti. I can see Muranga Prison is also logged on, which is very interesting. Mr. Kokonya, Bernice Kirwa. It's good to see all of you online. Good afternoon, everyone, and welcome to this webinar on mastering criminal litigation and the process. I think we have a fairly large number on now, and that's one of the reasons we were just waiting for a few minutes. So criminal law is something that very few of us delve into. Once we leave KSL and go into pupillage, we tend to move straight into the civil area of law. I was going around the country last week. I remember in Kiambu and Thika, when I asked an advocate who they knew about criminal law, the first names that came to mind were Danston Omari and Cliff Ombeta. And that's really sometimes how far the conversation goes. So one of the issues that came up is that why are women not in this field a lot more? And why aren't other advocates joining this field and trying to become experts so their names are used equally as well? So in conversation with Jamu Muredi and CD Kirenga, we decided to come up with this webinar, which is almost like a back to basics. So for those of us who went through the civil process of pupillage, we can actually pick up tips on how to prepare for criminal matters, how to deal with prosecutors, how to deal with matters in the lower court, the high court, and even the criminal appeals to the Court of Appeal. Because some of us learn literally through practice. And sometimes practice is not perfect. So you see your senior doing something wrong and you think that's the right way of doing things and you carry on doing the same thing. So I hope today we'll ask lots of questions We were supposed to have Jambo Muredi as one of the speakers, but unfortunately he got ill last night and he was admitted to hospital this morning. So we have CD Karenga, who's also a prosecutor based in Eldoret, and she'll be hosting the webinar for most of the time. Our two moderators today are Claire Karuga and Ogada Meso. And at this moment, I will turn it over to one of them to now take it forward. Thank you. Claire, you can take it forward.
Hi, everyone. My name is Claire Karuga. I practice in Eldoret, and I'm currently on the road, so you'll forgive me if there's any noise. I believe Mr. Ogada should be joining us shortly. He was in a meeting.
Yes,
But we have Ms. Okay, thank you. Let's proceed.
Good afternoon, colleagues. I don't have my glasses there in the car. My name is Ogada Meso. I'm an advocate. I practice in Nairobi. Ordinarily, I also do criminal matters. Actually, as we speak, I'm in one high-profile criminal matter. I'm glad to be here to share our experiences and ideas. And I'm also glad to be, what do we call it? To be a moderator in this session. Thank you very much.
CD Karenga, the floor is all yours. We look forward to a discussion. Thank you.
Good afternoon, everyone. I hope you can see me.
We can see you, CD.
Okay. My name is CD Kirenge. As stated, I'm a prosecutor based in Eldoret. I was supposed to be here with one Jamlek Muredi. However, as has been stated as well, he is not feeling too well, and I hope I'll be able to cover everything that he would have mentioned during this conversation. So the essence of it is that I was supposed to take us through the basics of criminal litigation, and basically starting from what the DPP does, or the mandate of the DPP under the Constitution, and moving on from the criminal trial process from the beginning to the end. So if I can begin with Article 157 of the Constitution, that is where the DPP gets its mandate. And this is basically to initiate proceedings, that is criminal proceedings, to take over criminal proceedings or to withdraw criminal proceedings anytime before the end of the proceedings take place in court. So that is where the office of the DPP gets its mandate, as well as to hire, or rather to each provides for the hiring of the actual director of public prosecution. And so, moderators, you let me know if I'm going a bit too fast or if you cannot hear me. So basically, this now, if you can go to the criminal trial process, the process essentially starts from the complaint. That is, any aggrieved party goes to the police station and records a complaint, which is written in something called an occurrence book, known popularly as the OB. So the OB is really indicative of the number and the date when the occurrence took place. And that is where the police officer would essentially detail the nature of your complaint. And so after this is what prompts for an investigation to take place. So when the police are done with the investigations, currently, right now, there's so much cooperation between.
When I went back for mention, the prosecutor is up to change, to amend the charge sheet.
sorry, I was saying that right now there's a lot of cooperation between the police and the investigative, and all other investigative agencies with the prosecution in terms of how they conduct the investigations. They are separate entities, but there is cooperation nonetheless. And where once such the investigations have been done and completed, then the same file, the collective file indicative of all the elements, including the statements as indicated by the various parties, and all the evidence, both documentary and non-documentary, are taken to the Office of the Director of Public Prosecution. This is for further consideration. Most of the time, the issues could be straightforward, and therefore it would be easy for the DPP to make a decision to charge. And that is written in the DPP's office has a document which are called the Decision to Charge Guidelines, which essentially talk about the issues that the DPP is supposed to consider or any prosecutor is supposed to consider before charging any accused person, including issues of whether there's enough evidence and whether there's sufficient evidence, and whether that is a matter that ought to go to court. Sometimes there are matters that come to parties at the police station or at the DPP's office or even to court that don't really need to go through a litigation process. That means they could go through alternative dispute resolution processes, which maybe we'll cover in a different area altogether. And other considerations that you'll have to go through before charging, including like public policy and public interest. So these are the determinations of some of the things that we look at when charging or whether making that decision to charge. And when that happens, it does not necessary that a person will actually be charged. The prosecutor can actually decide that it's better for a person to not be charged, or that more investigations take place, or that there is no sufficient evidence and to drop the charges altogether. So those are some of the issues that can take place there and then. So after that, then basically also to talk about the of a charge sheet. So that you note the charge sheet in the High Court when it comes to matters of murder is known as an information. The charge sheet in the lower court is known as the charge sheet. This details the name of the accused person or persons and the particulars, the offense, the particulars of the offense, and as detailed in the penal code or any other law that prescribes such an offense together with its penalty. So that is essentially what is supposed to be in a correct charge sheet. And a charge sheet could be defective if you rely on the wrong provision of the law in terms of the actual offense or the actual sentencing. However, this can be rectified at any other time before the close of the prosecution's case. I'm not sure if there are any questions at this point before I continue.
Siri, perhaps we'll take questions right at the end. Though I can see someone, can we see samples of the charge sheets and information sheet?
Okay, then that's fine. I'll take note of that for the end of this. Oh, okay, then just there's something that I forgot to mention. When after the complaint has been done and after investigations have taken place, most of the time the accused person is made aware, or when they are arrested, there's an arrest that takes place after that. And when they're made aware of that, they can either pay a cash bill or given a notice to attend court, which is not so common nowadays. So for them to be notified on a specific date on when to come to court. When this happens, then for example, I could be told like when, or rather an accused person, a suspect, they only become accused when they are arraigned in court or when the charges are read out to them. So they will be told to appear in court, for example, on 22nd of November, 2023, and they will pay a cash bill to secure their attendance at in court. At this point, this cash bill is known as the police cash bill. And when they do attend court on the specific day as directed, then that money or that cash bill is supposed to be surrendered to the accused person, such that if at all, when they plead guilty or not guilty, depending on the case, then the said funds could be used for them to either pay the fine or towards their payment of their cash bill or any other funds, or they could be returned to them just for their consideration. So now we've reached the point when we're actually in court and somebody is taking plea. The plea basically is it's a plea where an accused person at this point, because they are taking plea, has to either accept or deny the charges that are read to them. And so it's important for them, in order to accept or deny the charges, they have to be able to understand the language in which the charge is read out to them. This could also mean that the charges could be read out in a language that they understand, if it's English or Kiswahili. In some other courts, there are some accused persons, or in some other areas in Kenya, there are some accused persons who do not understand either English or Kiswahili, and therefore a translator has to be given to them in such a circumstance. Failure to which that could be a cause of concern later on, because that would mean that the accused person did not understand and therefore did not know how to plead. Aside from that, yes, so one could either plead guilty, in which case, then depending on the nature of the case, then the court would immediately sentence if it's a minor case, or if not, and this is another area of collaboration with one of the other offices that the DPP and the judiciary, or maybe what the court users, one of the court users is the office of the probation, in a situation where the court would need more information to assist it in sentencing, then it would request for a report known as a pre-sentence report. Basically, this would entail the victim's background, if at all they have any previous or prior convictions, or if at all they have had any other issues in the community or society. And this is where the police would be involved, the area chief would be involved, the parents would be involved, and the victim would be involved, so that you'd want to know the sentiments of the victims and all the other actors or people, community actors, before sentencing the accused person. So those are two circumstances where the court would just sentence just based on its own, their own assessment, of course, in line with the law and the judicial discretion, or based on looking at other situations that could be affecting the accused persons and the reasons as to why that person committed such an offense. So hence the pre-sentence report. In other circumstances, then the accused person might decide to plead not guilty, in which case, when they do plead not guilty, the practice is that they have a right to bail and bond. These are judiciary bail and bond guidelines that also helps judicial officers in terms of what sort of bail and bond to give. And it also includes looking into other circumstances such as the nature of the offense, the strength of the offense. Like this would mean whether this is a minor offense or a major offense, the age, the circumstances, and such other considerations. However, at the same time, in as much as bail and bond is a constitutional right, there are certain circumstances that could lead, if convinced, the court could, if convinced by both the investigating officers and the prosecution, the court could deny this right. And this is based on an affidavit that is filed by the an affidavit filed by the DPP in collaboration with the investigating officer, or rather the prosecutor in collaboration with the investigating officer, detailing what circumstances are so grave as so as to deny this person the bail and bond. And this could mean if they could have committed, if they're going to commit another offense within the course of this, or if you have such information, the issues and circumstances really vary depending on what matter we're talking about or we're looking into. And so once the accused person is given bail and bond, then they are also given a hearing date. And depending on the jurisdiction, they could be given a mention date either for pre-trial purposes. Like for pre-trial purposes, I mean, before when I talked about some of the rights of the accused, such as the right to bail and bond, the other rights that the accused persons have is that they are presumed innocent until they are deemed guilty. They have a right to a fast and expeditious trial, to remain silent should they choose to, and right to not incriminate themselves. But at this point, when I talk about pre-trial, I'm talking about the right to prepare for a defense. So technically speaking, the prosecution is mandated to give documents or all the information they intend to rely upon to the defense so that they can prepare for their trial or for their defense, to the accused so that they could prepare for their defense. So it's not a trial in ambush. However, just to note that also sometimes in some cases, the investigations are an ongoing procedure. So the prosecution could come up with or could get more information within the course of the trial, which information they did not have at the beginning of the trial, but they're still required to supply this to the defense so that they're able to prepare themselves in advance before they are heard. So we talked about the plea of guilty and not guilty. The plea of not guilty essentially now means now the matter goes into hearing after the trial documents have been given. And the hearing just begins, the prosecution begins its case. All the witnesses are heard. It reaches a point where then it closes the case and the magistrate or the judicial officer, depending on the case, will determine whether or not the accused person has a case to answer. This means that if they do have a case to answer, then the matter goes into defense stage. And if they do not have a case to answer, basically that means that they are free, they have been set free. After that, the matter goes, the issues go into the defense. Okay, now when the matter goes into a defense stage, the accused person is accorded a right to bring all his witnesses to court. He himself can testify. He or she himself can testify. The witnesses also given a chance to testify. And then finally, then both the defense closes its case, and then there is a judgment stage. At this point, both parties are given, at both points, actually during the, for the case to answer, and when the defense closes its case, both parties, that is the prosecution and the defense, are given an opportunity to file in the submissions. However, well, I mean, they're given an opportunity whether they should choose to do so. And then after that, then the judicial officer will give their sentence based on this. Sorry, their judgment based on this, and after that, a sentence. The judgment comes before sentence. The judgment is the
Sidi, if you can just, I see your camera has gone off. I don't know if you could switch it on.
Okay.
Please. It's back on now. It's back
Okay.
on. Okay, Sidi, you can carry on, please.
Okay. Yes, so I'm at the point where the judicial officer can gives their judgment after the close of the defense stage. And the judgment is a finding of guilt or innocence for that matter. And when there's a finding of guilt, then they'll proceed to give a sentence, again, based on the judicial discretion. And if there's no finding of guilt, then the person is, the accused person at this point is acquitted, which that is results in an acquittal, which therefore means that the accused person has been set free. However, at any given opportunity, then the prosecution still can withdraw these charges before the close of the prosecution's case. When that happens, if should they decide to do that, it doesn't exactly mean that the accused person has been set free. It would mean that at any one point, for one reason or another, if the prosecution wishes, if at that point they see they do not have enough evidence, or the evidence is not sufficient, or there are some circumstances where the case cannot proceed at that point, depending on the issue at hand, then they can withdraw it and reinstitute it later on. However, if that withdrawal is done after the close of the prosecution case, that leads to a full acquittal, and that means that the person cannot be brought back to court with respect to the same charges. So that's basically it when it comes to the criminal process from the beginning to the end. However, I have talked about two circumstances where the cases could be withdrawn. There are other issues, other circumstances where the cases could be withdrawn, including under Article 159 of the Constitution right now really tries to encourage parties to forgive each other. That is called ADR, Alternative Dispute Resolution. And so in line with this, the Criminal Procedure Code allows for a complainant in the matter to come to court and actually forgive the accused person in the presence of the court and the prosecutor. And once that happens, that is a full acquittal, and that means that the accused person cannot be brought back to court with respect to the said charges that had been brought in the first place. Also, additionally, sorry, I'm just looking at some of the questions that you have brought up.
Yes, Sidi, I see there are a ton of questions, and I think there are more coming in. So,
all right.
I think when you're done with your presentation, we'll go through them one by one.
Okay.
I agree.
Yes. Also, additionally, during the trial process, there are two other issues of alternative dispute resolution that can come into play. And specifically, I mean, there are a number of others, but the prosecution focuses on one that is called diversion, and the other one is known as plea bargaining. Now, we have documents, we have a diversion, the DPP has a diversion policy that basically elucidates what diversion is and what circumstances that could lead to diversion and issues like that. But let me just read it word for word so that I do not misquote it, that diversion is a method of restorative justice. It's an informal and non-adversarial process for the resolution of a dispute. Now, what diversion encompasses or what it acknowledges is that sometimes it's true that somebody could make a mistake. However, it's not always all the time that people have to go through the court process, or people have to be fined or sentenced, or have to go through that whole rigorous, the judicial system and litigation proceedings in order to feel like justice has been done. And this mostly happens especially when certain circumstances, like for example, if the person is a minor, if the person is a vulnerable person, if the issue at hand, sometimes if it's administrative or, yes, an administrative issue that could be corrected in another way, such as payment of a fine or a payment of something that had not been seen before. Let me give an example. In the cases of minors, there are sometimes when minors commit offenses. There are some offenses that the diversion does not apply to, such as sexual offenses, especially that has happened, then that diversion has taken place. What essentially happens there and then is that the office of the DPP, the prosecutor in this case, will indicate a diversion. The office of the DPP would create, there's a document known as a diversion agreement, where it indicates the nature of the offense conducted and the conditions that have been done or that have been set for the person to have been set free. For example, that there was a public apology, that the person has been cautioned, or that they have been told not to repeat the offense within a certain stipulated time, or that payment has taken place. Sometimes the restorative justice is in form of a payment. So that is what is indicated in the diversion policy, which would then mean that the matter would not proceed in court. However, sometimes the diversion could also take place after a matter has been instituted in court, if there are means of that, or if the parties agree to it, in which case the diversion policy is adopted in court and the parties just agree that they have allowed to withdraw the matter, and it results in a full acquittal, which therefore means in this particular circumstance, when it comes before the court, there's no conviction and the person has no criminal record. Yes. So the objectives of the diversion is that somebody, or rather the conditions and circumstances where we would ideally agree, is where somebody has accepted responsibility or is accountable to the victim, or they have paid and it's a transparent issue between both parties, the complainant and the suspect in this case, or who they would have been accused. Aside from that, the other issues, the other method that we adopt within the criminal process as a prosecutors is the plea bargain. Now, this a plea bargain, in short, or rather to just simply put it, is where the accused person sits and agrees with the prosecutor on agree to pleading of guilt on a certain circumstance. It's a negotiated agreement. They negotiate and they agree where to plead guilty to an offense in exchange to a certain condition from the prosecutor. And that would mean either lessening the charge, one or many of some of the charges that somebody could be facing, or recommending a specific sentence, which some cases would mean like a lesser sentence or a sentence of probation or community service, depending on the issue at hand. Or it could also mean the withdrawal of a particular charge, especially where the person could be made a witness, and that would help the prosecution in terms of pinning maybe another accused person with respect to many other charges. So it basically depends on the offense that is before the specific prosecutor and what is a better outcome for the prosecutor, and not exactly in terms of convictions, but what would result in a better understanding. Because sometimes we also realize that some people are used to make in the pursuance of commissions of crime, and it's better to use these people also to help pin other offenders as opposed to make them co-accused persons. So those are some instances where plea bargain could take place. Again, how does this happen? Any of the parties can initiate this. It could originate from the prosecutor themselves, the accused person themselves, the accused person's advocate, or even at times, yes, we could initiate from any of the parties who are interested or willing to pursue a plea bargaining agreement. And that agreement, once it's done, again, there's a detailed agreement that we use, and it is in the plea bargaining guidelines. And once it's done, it's also adopted in the courts. And especially because most of the time when this happens, this happens most times when the matter has already come to court, because you will notice that there was already a drafted charge, and which will have to be lessened, or the matter has already been in court, and therefore we'll have to think about a sentence because somebody has already had to plead guilty to a charge. So yes, that is the essence of the plea bargaining and the diversion policy. I realize I've been speaking for a while, so maybe I could take that, now that we've reached that stage, you take that as a breather.
So I think that's fair enough. I don't know if Ogada and Claire are with us. I know they're also in court in Thika and Kitale. Perhaps you could start with a few of the questions that have come in before you carry on.
I think I'll go first, before we open the floor to our colleagues. CD, now I have a lot of questions, but I think I'll just ask one and leave others to also ask some questions. Now, I find a problem with plea bargaining, and especially you find that, let's say, 2 or 3 people are involved in a criminal transaction, and then one of them turn out to be a witness against the 2 others. I think that's not proper. For me, if the 3 were to go for plea bargaining, I'll be of the idea that the prosecution considers all of them. If, let's say, they are now to be charged on a lesser offense, they are considered the 3 of them, not
that turns out into against the others. I think I have a problem with that. Perhaps from where I sit, it is a ground for review. I don't know what you think about it.
And based on the circumstances, then again, the prosecutor could either choose to agree or to deny such a request. Again, it's very difficult for me to speak collectively on behalf of all prosecutors, and given that this is a diverse nation, a diverse country, it depends. In some circumstances, for example, if there have been a number of situations of robbery with violence based on a certain group of people, and the target is to apprehend or to get these sort of people, it will not be in the best interest of the community or the prosecution to agree to a plea bargaining negotiation in such a situation. Or alternatively, it would be better if you consider the evidence of one person against the other two person to pin maybe the kingpins of such an institution or a crime institution, if you get my drift. So it is not that it's a standard application in all situations. It depends on the situation, the offense, and actually even the community's security or the community's, the public interest at the end of it.
Yes, I get you. And I know it is only applicable in, not in a uniform way. Though, perhaps now to rephrase the question I was saying, don't you think that it is not proper where I'm involved in a transaction with my colleague, and then from where I sit as a defense advocate, we usually believe you've influenced the other, one of the parties to testify against the others. That's what I mean.
I hear what you're saying. I hear you're coming from. Again, I don't believe that is a standard practice. It's not that we influence. Again, the plea bargaining comes from, sometimes initiates from the accused persons themselves. So if they approach you with more information than you already have, I would be inclined to hear that information.
Okay.
However, again, that is it. I might have a different opinion from somebody else, so don't take my full bad for it, just because of the difference in application.
Very well. I think it's an area I want to pursue, and I will share what I'll come up with. Thank you very much.
CD, perhaps we can deal with a few questions in the Q&A. I see we have 49 at the moment. So perhaps you can deal with the first 5.
Or let me just look through them and I continue. There's a question about the revised cash bail in open court.
First one is, who drafts the charge sheet, the DPP or the police? That's from George O'War. Who drafts the charge sheet, the DPP or the police?
We are the drafters of the charge sheet. We are the ones who approve the charge sheet. So a charge sheet will only go to court once it has the signature of a prosecutor and the designation of that specific prosecutor. Without that, then that charge sheet is not valid before the court.
Okay, I think we're going to come down that road, because I see an anonymous attendee says, what do we do when a charge sheet has been drawn, but the police officer refuses to arrest the accused and take him to court for plea taking, which is a bit strange. But then the next one is, how many counts would render a charge sheet defective? And other examples of how a defective charge sheet is identified. That's by Bernice Kirwa. Perhaps you can deal with all those 3 together.
Okay. What do we choose when a charge sheet has been drawn but the police officer refused to arrest the accused? That is a very weird situation, perhaps maybe the person could explain further. Ideally, when the charge sheet has been drawn, the accused person should appear in court, and they should have the police, either they appear in court because they have already been arrested, or they have a cash bail notifying them to appear in court on a certain day. So failure to which, then a warrant of arrest should be effected against them. Now, a situation in the opposite would make one have to summon the specific arresting officer on why that has not been done, because in the absence of the accused person, then it's either one or the other. How many counts would render a charge sheet defective? No, one charge sheet, this also subject to conversation, but I mean, sorry, for purposes of ease amongst us, one charge sheet, I think there has been a ruling that said that it should not be more than 12 counts. So this is what has been applied as a standard. However, yes, this is what has been applied as a standard. One charge sheet should not have more than 12. But duplicity of charges, there's an answer there that has been placed. This is different. This is when two different offenses are encompassed in one count. So when you put two different offenses in one count, that makes it a duplicate count, and that would mean that it cannot stand on its own, so it have to be separated. Yeah, how a defective charge sheet is identified. I think we've already covered that on the duplicity or the wrong sections of the law and sections of in terms of the offense or the penalty.
There's an interesting one here from Edwin Kokonya, which says, in cases where a prosecutor decides to withdraw a matter under Section 87 without the consent of a victim in a SOA case, which I've not heard of, but what is the best redress available to victims? Revision, complaint, or private prosecution?
Ideally, the prosecution is not allowed to withdraw sexual offenses matters, especially if the complainant is willing to pursue it. So when that happens, then I think the best thing is to send a complaint. My apologies to all the prosecutors who are also listening in, but that would be the best thing to do.
Georgia War is asking, in accordance with the decision to charge guidelines, are there also guidelines that give directions on arrests, the basis or factors to consider before arrests? I don't know if that's within your jurisdiction, but you can answer that as well, if you don't mind.
No, I think it's just important to note that we are different institutions. In as much as we cooperate, the mandate to arrest lies with the police. And so when it comes to the prosecution, the mandate there now, in as much as there's prosecution-led investigations, that is with intent to just making a decision to charge. So we do not cover the issue of arrest. However, after receiving a file and looking through the evidence, you could then direct the investigative agency, depending on which one it might be, to arrest and or rather to arrest for purposes of charging somebody with an offense.
There's maybe one last one you can deal with in the question and answer. It says, in what instances would the defense counsel file a formal application for bail or bond?
Well, as said initially, the bail and bond is constitutional right. However, there are situations where the prosecution would come in advance and say that they feel there are circumstances where the accused should not be granted bail on bond, and these circumstances have to be so you'd have to convince the judicial officer as to the nature of the circumstances, and in most times have proof of why you think, like, you could say that the person is anxious, but I mean, it's just that, but you'd have to have proof with an affidavit showing why you think that is the position. And when the defendant would come in with a formal application, you need me answer. But
Siri, are you still online?
yes, I am still here.
Okay, I think we've answered about 5 or 6 questions. Can we carry on with your presentation?
Yes, sure, we can. So after this, oh, sorry, there are some other issues come up, like for the issue of inquest, basic situation where there have been a death and you cannot tell who is suspected to be at fault. So it has to make a determination as whether or not there is anyone at fault and whether there should be a charge to be instituted against one or many of the parties there. Basically, this is that is what it is in short. And in other circumstances, then even a prosecutor would look through the said file and through it and just give an admonition themselves as to whether or not the matter proceed by way of inquest, or in their own assessment, they look at it and determine whether determine whether they will decide to charge an or the next available court, depending on where the initial matter had been placed. And so there could be an appeal from the High Court to the Court of Appeal, or from the Court of Appeal to the Supreme Court. I think I should have covered maybe basically everything that I was to cover from the beginning of from the beginning to the end of the trial process. And I stand guided, maybe be better off with more of the questions.
Okay, Siri, you can see the Q&A box.
I can.
So I say, okay, I think that at the top.
I don't believe so. The standard is that you have 14 days right leave to file an appeal. How long should an inquest last? I believe this just depends on, honestly, there's no correct answer to that. If it's just like any other criminal procedure, supposed to bonded here in court when they're called to. The reason as to why they usually take longer is because maybe sometimes in the form or don't need to, like in and if not, sorry, could you repeat that?
Is plea bargaining tantamount to admission of guilt? That's from Doris Amisi. And another one, who initiates diversion?
Okay. Plea bargaining tantamount to guilt. Again, it depends. Technically speaking, yes. You know, the circumstances, what will be, the accused person would be asking for in a plea bargain is that they want to plead guilty either to the charges that they have, but they do not want to plead guilty to the charges because either the charge is too high, and therefore somebody would have to, the prosecutor would have to lessen it, in which case when they let it, they're still pleading guilty to the lower charge. Even when they're pleading guilty to the lower charge, then they still have to be sentenced, and when they sentence be a sentence, but it's still a sentence nonetheless. So as for the,
I think our host network is not very strong. And that's why
sorry?
the net, I think our network at Secretariat is not very strong.
Okay, that's
Have
why
you
I
seen
keep
the other
saying record.
questions? There's some questions in the chat.
Okay, let me look at them. There's a question about when an accused person is acquitted, are they brought back again to court? Will they be considered as a first-time offender? When you're acquitted, you have been found free of all the offenses that you have done before. Therefore, that is not a prior, there's no prior conviction. You literally have no prior conviction because you have been acquitted.
So Morgan Obimbo asks, what extent is it allowed for a prosecution witness to be someone different than that who signed the statement? And what is the remedy if the court continues with that witness who didn't sign the statement? Siri, are you still online?
I am still here. Can you hear me?
Yeah, so what it says is, what extent is it allowed for a prosecution witness to be someone different from the one who signed the statement? And what is the remedy if the court continues with that witness who didn't sign the statement? So I'm guessing one person wrote a statement just like the one I've just received right now, and then someone else comes to testify. Is that even allowed?
I don't believe so. Although,
Yeah.
I mean, most of the statements that are written in the police file are usually mostly written by the officers themselves. However, the signature at the bottom is the signature of the prosecution witness that has been stated at the top. The only instances where somebody else could testify on behalf of others is, for example, maybe in a sexual offences matter, mean, where a child is involved and this child does not have the capacity to even write, or a person who is mentally unstable. So we refer to them as vulnerable witnesses. And where the court has declared somebody a vulnerable witness, then they can somebody else can testify on their behalf. However, this does not mean that the other person is giving the actual testimony in court. It's that they're translating how they understand what the actual person is saying. So it's not that I become a new person saying what I have to translate what the person is saying in court to the court for the court to understand, because of the person, the circumstance where the person talking.
Okay, I see one from Thomas Keegan. It's prosecution hearing.
We're allowed to amend the charge sheets anytime before the close of the prosecution's case. However, sometimes I have noted even in the judicial officers can, if they note the issue with the charges, they can also do so from their end, especially if the evidence that was given was in line with the specific charge that they believe in conflict with the law. Again, it depends on the issue at hand. If it is an issue of, there are some circumstances where the prosecution would apply diversion, and therefore a child in conflict of the law would somehow be forgiven or asked to maybe say an apology directly to the tenant or to the victim, or yeah, that would be one of the instances. However, there are times when they are actually charged, and when that does happen, they are treated as children still, because they are separated from adults in terms of where they are placed. When they take, into special, like children that is held for the yes, I believe that could be the position. However, that is attached with some conditions to it. And this is what I believe the moderator was talking about before. When, for example, if the condition would be to testify on, to testify in some matter or some other matter, or just something like that, because you're giving the person a free pass, but for assistance in another matter.
Sidi, this is one you can touch on. I've seen a few questions on it. The issue of watching brief and taking part in proceedings. I could answer it myself, but perhaps it's better if it comes from prosecution counsel.
Well, just to start off, I believe prosecution counsels are very happy to work together with counsels watching brief, because we are all working for, basically for the rights of the same person, that is the complainant. So yes, that is the general position, I believe, from my perspective. in terms of their participation, they're supposed to work together. Ideally, just a second. They're supposed to work together in terms of the questions that are posed to the accused person. However, this I've read in a recent judgment, or rather, where there are situations where there are some questions that have not been posed, then they have the right to cross-examine. And so some judicial officers agreed to that. This is basically in protection of the right of the victims and just to ensure that it's not a repetition of what the prosecutor has already asked.
Yeah, thank you for that, CD. I always like to ensure I'm aware at the start, and I make the court aware at the start that I'm there watching brief, and then I always ask for guidelines on when I will go and when I will go next. So that way, at least we have a procedure in the court with regard to questions and who's going first. So I normally go after the prosecutor. But thank you for that. I don't know if you've seen any more questions on the chat.
So I think most of the questions are about plea bargain. Can an accused person recant a plea bargain after it has been entered and resume normal hearing? Yes, it's possible. There are times when after drafting the agreement and the person looks at it and they decide no, they do not. Once it's being taken to court, they can recant it then so that it is not adopted by the court, and therefore proceed with the normal hearing. There's somebody who has asked about the victim impact assessment. This is one of the reports that are written just before sentencing, and just as it insinuates, it's the sentiments of the complainant or the victim, mostly done. For example, you find in traffic case, especially after the death of someone, mostly done. However, it can be done in other cases, and so the victim impact assessment report is mostly done by a probation officer, where they look at the feelings of the complainant of the victims who are involved.
So I've seen some questions in the Q&A. How many times can the prosecution amend charges? Hello, CD.
To be honest,
are you still online with us?
To be honest, allow me to give a proper answer to that. I would not want to let that person. Somebody has asked about murder charges being prosecuted at the Chief Magistrate or High Court. Murder charges are at the High Court.
CD, wasn't there an authority, though, that said murder should start at the lower court because it denied them the extra stage of appeal? And do we blame Kenya law reform for this?
Again, I'd have to get back to you on that.
Okay. I'm just thinking because I think it was my senior in Kisumu, Richard Onsongo, who filed that petition. Nonetheless, we can proceed. Some of these questions, of course, are not directly related to you as a prosecution counsel, but I see one here from Mr. Githimbu. In an inquest where the deceased is presumed to have contributed to their death, as counsel for the primary suspect, Can one move the court for physical sitting to the accident site? Courts, particularly lower courts, tend to be averse to this. Is there a provision to this for prosecutors?
I don't believe there's anything wrong with that. I believe you cannot allow as a council to move the court so that they can, because the purpose of the inquest is to make a full determination on who's at fault. And if you believe that a site visit is going to prove that your client is not at fault, then I don't see why you should not move the court.
Okay. So another one from Nganga here. As counsel watching brief, I realized that the facts, evidence, and description support a higher crime. How do I move the court to substitute the charge? Also of importance, how do I do it from a lower court to a higher one?
Sorry, who was that question from? Can we just repeat it again?
Nganga Wangi says, basically, if he realizes the facts, evidence, and description support a higher crime, how does he move the court to substitute the charge? Also of importance is, how does he do it from a lower court to a higher court?
I think that is an issue of amendment. That's your current speech.
Hello? CD, you're still online?
How are you?
CD, are you online with us? Claire?
I think perhaps a minute. Byron, on that question, is joining on behalf of the accused person.
To rejoin us.
Byron, you can take down those questions by Edward. Miss CD can come and address the same. While you are here, I have a question as well. Yeah. On the issue of when we're going for sentencing, and we have the accused person having been in custody while doing the hearing, should the judicial officer take into account the number of years or months that the accused has served while doing the hearing, or when they're sentenced, it will start afresh from the date of the sentencing, because I'm having a pro bono matter on the same.
Okay.
And the accused has served for Byron. Okay. The accused has served 1 year in prison while she was doing the hearing. From the judicial, or is it on the judicial officer to take that into account during mitigation? If anyone has an answer, they can also post it in the chat. Thank
Claire, I've heard a few registration judges take that into account. Some don't refer to a policy with regard to this particular. City, are you with us? In the trial. We have an anonymous attendee saying that can the parties agree on an out-of-court settlement when the matter is ongoing? Will this mean the accused is pleading guilty? A very quick one, CD.
No, I don't believe so. When they agree on an out-of-court settlement, then the complainant agrees to that settlement, basically. They can come to court and formally tell the court that, in which case it's an acquittal.
Okay, Ivy Carey says the time spent in custody is taken into account when sentencing. If not, you can apply for review. Thank you for that.
You would need the medical report. But in this particular instance, I think it would the medical report that would help is that one of the female. However, they look at some judicial officers' decisions on such cases where they rely on the just evidence before the court to prove, I'll be honest. But however, judicial officers had largely relied on the evidence of the child, especially if they're not basically in I think you can just formally move the court with an application. Explaining the reasons as to why you would wish to be part of the proceedings. There is a question on whether the court can rely on a medical report that has been done without examining the accused. I think it would have to be for you to prove how the examination was not done without examining the accused person. Yes, it depends on the circumstance, because most of the time it can rely on a medical report that was done on examining the complainant. So they could rely on that.
Claire,
So there
perhaps
is a
you can work
question.
down the questions that are outstanding.
Byron, you can proceed.
No, Claire, perhaps you can work down the questions. I see Bernice has also posted one again. Examples of how a defective charge sheet is identified.
I think we might have already covered that at the beginning. That was sent at the beginning. This is issues on like the defect in the law. The next question is there a time limit for when an accused person is allowed to collect a cash bill after case is dismissed? That is highly determined by the judiciary based on their processes, because you have to formally collect it from, I believe, the bank, or it's going to be sent by the bank because of how the deposits are made. If a person is of unsound, most judicial officers do that.
And when they don't, how is what is the procedure of having this taken into account?
Well, most now then they would ask for resentencing. This is asked for resentencing and asked for at a higher core amount of time. In case the judicial officer in most cases would like to plead the fifth on that on that particular. It's a highly debatable area. I would like to share my opinion, but that is a personal opinion that I have, and I would not want to declare it as an opinion for the whole office. So, in terms of the reforms, I'm not quite sure exactly, because people have differing opinions.
There's a comment, I think, by Sheldon. I'm trying to rephrase the same, but I believe it's along the lines of how the jails are usually accommodative to the prosecution counsel, but when a defense is trying to adjourn a matter, it's usually you'll see a lot of backlash on the same. So I don't know if they want you to comment on the same.
I would differ. I've also seen instances where some are very lenient with the maybe this is just an issue that could be addressed where
are not asked and they'd wish for the witnesses to be recalled. How should one go about it?
Okay, the advocate can formally make an application to the court, in which case the prosecution could either agree to it or disagree. Most times, if you see a prosecution counsel disagreeing, that is because they feel like it would be very difficult to get the witnesses to come and testify again, or if the matter has been fairly old and had really proceeded, or if the accused person had been given also a sufficient time to get a counsel and only decides to do this at the tail end of it, maybe it would be seen in some instances to be like a waste of time, just trying to push the case backwards or not finishing time. However, if none of that is happening, I don't see a reason as to why the prosecution, if they will fail to accept such an application.
That answer that you had given, someone answer correctly.
Yeah, it's I mean it's a bit how documents cases which maybe I can share later. When they look at such instances, and especially in the absence of any other witness, because most of them happen, the court would heavily rely on the information given by the minor, if they can sufficiently see that the minor was actually being truthful as to what happened in the circumstances then. So it's yeah, it's you look at the medical records, especially of the suspect, and the truthfulness of the minor, especially in the absence of a witness.
Okay. And what about where someone has been acquitted on appeal and you want to expunge the criminal record so that they can get a certificate of good conduct? How does one about that?
Because time impossible. And some of the situations or some of the complaints done are very time sensitive, and therefore they would require for investigations to be done almost immediately. Others can take time because they might have to look into records. Others might even take longer because you'd have to go through some maybe forensic and cyber issues that would need a lot of further investigations. However, if you feel like your matter has taken too long to be in various head of the investigative agency, which is still not maybe not that to the nearest closest one to find out the Okay. Now I'm assisting defense counsel, but it's okay. Anyway, I mean, the matter can start de novo because either the accused was unrepresented and felt like they needed representation. There's some specific cases where the judiciary have seen like accused persons need to have representation, for example, those of murder, or if it's robbery with violence in some instances, or where the person is a child. So if the matter has proceeded and the child was represented, then that is an instance for which to start novo. Or if just as somebody else had asked, where an advocate has come on record later on in past, or somebody was examined properly, they could ask for it to start de novo. If the accused person was not
A complainant should accompany the police in making the arrest.
Unless you really want to, I don't believe you should be there should be no reason to do so.
Then there's a question on questionant accused evidence of prosecution.
The right to and therefore the information used by the accused to pin them down.
Ms. Sidi, perhaps I see we have 20 minutes to go. Kindly, if you may briefly touch on diversion and plea bargaining, then you can take the rest of the questions.
Okay, we had spoken about diversion and plea bargaining before. However, in short, diversion is an informal and non-adversarial process for the resolution of a dispute, which would mean that, and instead of going to the full court proceedings or engaging before that is filed themselves, or the computer themselves have affected this as a mode of alternative dispute resolution. So it's part of the alternative dispute resolutions that have been agreed upon in line with Article 159 of the Constitution. And the DPP has also adopted it as a policy, and we have a diversion policy that supports this. And when parties agree to, it's mostly initiated by the parties, and mostly initiated by the prosecution counsel or the counsel, the prosecutor, who will sit the parties down and agree on the terms of negotiation, conditions, some of which have just, some of these issues could also mean that somebody is given a caution or for the sake of a child where they are told that not to repeat something like this, like after 3 months, or to the probation parties benefit from the process at the end. Plea bargain, on the other hand, is an agreement, a negotiated agreement between the person where the other agree to a lesser sentence or a lesser charge, depending on the circumstance. And basically, this will happen after court as opposed to the full sentence with respect to it. So as communicated earlier, the plea bargaining agreements usually differ depending on the circumstances. There's no blanket way of having a plea agreement, the bargaining agreement. It's not standard, so therefore it would depend on the issue at hand. There are plea bargaining guidelines. If anyone would like to take a look at them, they're also I think you can find them online. So as the diversion policy, you can still find them online to know better about them. But that is a brief overview on the two issues.
Okay, thank you, Sidi. There's a question on, so when a complaint has been made at the police station, what is the procedure to follow? Should the suspect be summoned by the police, or are the police officers allowed to go and arrest the person for purposes of bringing them to the station for them to record a statement?
The procedure, you only arrest a person when you have confirmed that, when you have done investigations and determined that somebody has a case that they should be taken to court before. So an arrest, they should be summoned, a suspect should be summoned to the police station. And after that, then after the investigations are done, that's when an arrest has been made. Can be made rather.
Okay. Then for accused persons who have been convicted and they have served their sentences, is there a possibility of them getting a certificate of good conduct?
I am very doubtful of that. I'm not sure. I don't think so.
Okay. Okay. Then question on, can a statement of a co-accused be used as evidence against an accused person?
You cannot use, technically speaking, you cannot use one accused person against the other person. Yes. So unless you start and decide to use there must be something off about that, because usually even in the judicial process system, they have, when somebody is in remand, then there is something called a prison mention, where the accused person has to appear, is supposed to appear before the court, just to see that they are okay and that they are fine before, and to be reminded of their hearing mention dates. So there might be something a bit suspect about that. So you actually need to get further to find out why they're not appeared in court, unless they personally don't want to. They have to appear.
Okay. Good afternoon. When coming on record for an accused person during the trial stages, what document does one enter appearance with, and what is one supposed to request from the prosecution?
This one of instances, cases, you will just, once at the initial of the court, just mention to the court that you're appearing on behalf of the accused person in order to prove their case.
Okay. If the IO fails to testify, does the criminal proceedings fail the test of time, and is the accused person automatically acquitted?
Not necessarily, but not really even sometimes the instances where the litigator is not there or cannot be availed on behalf. Sorry, is it what?
Is plea bargain appealable? Miss D?
Sorry, yeah, I was just actually looking at the last question, which made me laugh a bit. Somebody's asking if the plea bargain is
Yes.
well, that would be a bit hard for a person to appeal against, because it's very difficult and uphill task to go.
Thank you, CD, and thank you, Claire. My apologies, I was called away because there's always pending work for a lawyer. But thanks to CD and up the DPP's office with diversion policy. No Mundia about it. There's a magazine, whatever it is, it's everything. Who can request for diversion made? When can when it's laid, the diversion. So for the guitar or Lucy Raphael or Wilson Wihuri, I think it's also an area we need to start charging in a different way because we undercharge. I think it's an area that a lot of women need to get into as well, because again, it seems to be underrepresented within that particular gender. But let me thank everyone for attending. I hope all your questions have been answered. If you're still stuck, reach out to any of the speakers, the moderators. We'll be happy to assist in any way we can. And yeah, just focus on practice. That's the only way forward. I know it's campaign season. Campaigns are not going to get money in your pocket. It's your specialist skills as an advocate, which will mark you out as one of the top lawyers, which will lead to referrals, which will lead to you being sought after, and will lead to be able to charge high fees, which will make you rich. So I wish all of you a great evening. Enjoy Nairobi and anywhere else around the country, and thank you very much for attending. Have a good evening.
Thank you as well.